Hello, and welcome to Optimum Solutions Educational Webinars. My name is Susan Warren, and I'm a member of Optimum Solutions support team. I'll be your host for the educational webinars. For our educational webinars, we've selected topics that we think will be of interest to payroll and HR professionals, and we hope you learn lots of useful tips from watching our educational webinars. If you think of other subjects that you'd like to see presented, please email me at swarren@optimumhris.com. Thanks for watching and enjoy the webinar.
Welcome to Optimum Solutions Department of Labor Investigation Basics webinar. My name is Susan Warren and I'll be your presenter today. How do you think you would stack up today if you received that dreaded notice from the Department of Labor that they wanted to visit you for an on-site inspection of your records? Would you assume the fetal position in a corner of your office and start whimpering? Or would you confidently begin to lay out your plans to satisfy the investigator's quandaries because you know you have been compliant in every aspect of the law? Or might you be somewhere in between these two extremes? After our look at Department of Labor Investigation Basics today, I want you to better understand how you can avoid litigation in the first place, because that's where you really want to be, in a situation where you are in compliance, where no employees can find fault with your overtime calculations or payments, where no Department of Labor investigations would ever be required. I want you to understand what the Fair Labor Standards Act calls for. What must you do? What can you do? And what can't you do? And if you do get notice that you will be investigated, I want you to know what to expect. In an effort to steer clear of, or at least be prepared for, any Department of Labor audits, I want you to take away some ideas for best practices. What can you put in place so that you can be sure you're in compliance with the laws? And about those laws, know the gotchas. What are the red flags that call attention to the Department of Labor? You do not want to waive those. Now, please remember that Optimum Solutions does not provide legal counsel. The information we provide in educational webinars is general in nature, and examples are for illustration only. We encourage you to seek legal counsel if you have specific questions or if you face litigation. For almost every company represented in our audience today, the cost of human capital is the largest expense that hits your general ledger. If you work in a manufacturing industry, I am sure that detailed records of every item shipped and received are kept. So why would you keep any less detailed records of your labor expenses? Gone are the days of paying workers out of a cash box at the end of the workday. And while unions may have helped, it's easy today to put in place your own good rules for capturing and tracking labor data. And keeping complete, detailed time and attendance records is the first step toward avoiding litigation. It can be tricky because litigation can come at you from different directions. There are wage and hour laws at both the federal and state levels, and because there are 52 sets of state laws, and we only have 30 minutes today, we're going to concentrate on federal wage and hour law. That centers around the Fair Labor Standards Act, which has been around since 1938. And to give you a little bit of perspective on 1938, I think you've probably all seen the movie The Wizard of Oz. That was made in 1938 when Technicolor was new. So the Fair Labor Standards Act and Technicolor are about the same age. The Fair Labor Standards Act mostly deals with 4 topics: minimum wage, equal pay, overtime, and child labor. I don't want to go down a rabbit trail here, but actually there is a lot of talk among legislators right now about possibly revising some of those jobs without benefits. Talk is about workers' rights, especially rights to benefits. So in our work lifetimes, we may actually see some changes to the 1938 FLSA. In most cases, state labor laws are the same as federal labor laws when it comes to minimum wage, equal pay, overtime, and child labor. However, there are some states where some of these are different. When there is determination of an FLSA violation, the employer must comply with the law that is most favorable to the employee, either the federal law or the state law. Historically, California, Illinois, New York, and Texas have accounted for approximately 1/3 of all FLSA violations. And in case you're wondering why these 4 states, they are the most densely populated, except Florida is actually number 3, but because there are so many retirees there, it falls out of that list of Fair Labor Standards violations. So, for example, federal minimum wage is $7.25 an hour, but California minimum wage is $11 an hour. So a California Fair Labor Standards Act violation that involved back pay of minimum wage would be based on the California minimum wage of $11 because that is more favorable to the employee than the federal $7.25 an hour. The top industry violators include food service, retail, like gas stations or grocery stores, construction, hotels and motels, agriculture, and healthcare. And some other industries that are very high on the scale of violators are hair, skin, and nail salons, apparel manufacturers, and auto repair shops. If you use common sense to think about this, it makes perfect sense. These establishments very often employ minimum wage workers, a lot of minimum wage workers, and sometimes those workers have impaired English language skills, or they are workers who are not very familiar with U.S. law. Now, in order to avoid litigation, one of the biggest hurdles is to understand these requirements of FLSA. You should clearly define in writing to all employees your work week, which is any 7 consecutive days beginning with the same weekday every work week. Define your work day, which is a period between the time when an employee begins and ends his or her principal activity. Define your pay period. Is it weekly, bi-weekly, semi-monthly, monthly? And publish your rules and policies for working off the clock. Publish your policies for employees approving or acknowledging accuracy of their time, your policies for meal and rest breaks, and your policies for preliminary and post-preliminary donning and doffing time and prep time for employees getting ready to work. And also your policies for travel, training, meetings, lectures, and conferences. It's important to publish these policies because infractions of these rules could mean disciplinary actions. So employees need to have a very clear understanding of these rules, and you need to consistently enforce these rules. It is the burden of the employer to correctly classify exempt and non-exempt employees for overtime purposes. And the employer must use the classification that provides the greater protection to the employee. That is, you can't just use the classification that means you pay the employee less because it gets you out of paying them overtime. You have to use the salary test, and you have to use the duties test, and you have to consider whether they are a salesperson. This may be the time for you to scrutinize your job descriptions, and we'll talk about that again in a few minutes because it's really important. We've established that you can't misclassify exempt and non-exempt employees just to get out of paying overtime. So when do you have to pay overtime? FLSA says you have to pay overtime to non-exempt employees who actually physically work over 40 hours in your defined work week. So what about those hours that are not physically worked, like sick and vacation hours? There is no federal requirement that you have to pay for those hours. Actually, there is no federal law that governs anything about vacation leave. Now, I am not saying that you should go and change your policy and stop paying for those non-worked hours, because you would certainly have mutiny on your hands. But it's nice to know and nice to share with your employees that you're doing something for them that goes above and beyond what the law requires. Some states do have their own overtime pay requirements, so make sure you are familiar with yours. Okay, it's time for a pop quiz. What happens if a non-exempt employee works overtime without permission? It's an honor system, so you each get to grade yourself. If a non-exempt employee works overtime without permission, you must pay him or her for that overtime. But you do have the option to discipline the employee for violating the company policy that you published. Remember the one we talked about back on slide 7? That prohibits them from doing this. What should you expect if you receive a notice that you're going to have a Department of Labor investigation? Well, first, let me tell you a few things about Department of Labor wage and hour investigators. They are humans. They are nice, normal people just like you and me, and they have a job to do. They appreciate honesty and cooperation. While ignorance is no defense, they really appreciate people who have done things in good faith. They are not there to be your best friend, but they are there to make sure the rules are being followed. First, they will investigate any complaint to determine if Fair Labor Standards Act is applicable to the employer. If so, their main concern is to make sure that the employees are paid according to wage and hour laws. An investigator has the authority to conduct an investigation, collect data, enter and inspect an employer's premises, inspect employer records, and question employees. Here's how a timeline might go for a DOL investigation. The employer is slated for investigation and the notice is sent to them. The employer receives a request for documents that the investigator needs to examine, and that's typically time cards from a specific period for a specific group of employees, but it could be different documents. An on-site visit is scheduled for document review and personnel interviews. And did you know that your company can have a published policy for Department of Labor investigations? And if you have one, this would be a good time to send it to your investigator so they know what you expect from them when they visit your site. There will be a final conference where findings are presented. There's a letter or a notice of those findings, and there can be an employer response to findings. The natural response to an announced investigation is, why us? What did we do to deserve this? Because the Department of Labor is so concerned with preventing retaliation, you may never know the answer to that question. Almost all investigations are the result of a complaint filed by an employee or a group of employees, although some investigations are simply because of your industry or your geographic location. Earlier, I mentioned how a timeline might go. But actually, investigators are not required to give you advance notice. They are allowed to just show up on your doorstep, and you must cooperate with them. This is when it's a good thing to have either a wage and hour attorney on retainer, or at least a legal department in your company. Payroll and HR and legal should all be best friends. You should train anyone at your company who might come in contact with a Department of Labor investigator, either announced or unannounced, on exactly what to do. And this would include someone who answers the telephone, your receptionist, someone who sits by the door, someone who sits outside of your department, anyone who might come in contact with a DOL representative. They should be courteous and polite, but say nothing else. No friendly conversation. Don't make excuses for why the conference room is so messy. Just be courteous and polite. Lead them straight into the nearest private, quiet conference room. Offer them some refreshment while they wait for the payroll or HR or legal personnel. When your company's representative meets the investigator, you may ask for his or her Department of Labor credentials. If you've sent them your company policy regarding DOL investigations, they must comply with your company policy. You cannot deny them access to what they ask because they do have subpoena power. And if you don't show them the records they ask for at your location, you'll show them to them in court. Usually, investigators will send prior notification that they're going to visit, so begin to gather the requested documents immediately. When they come, they will explain what's going to happen and what they need to see. They will likely ask to interview some employees. Find a private place away from noise and other employees for these interviews to take place. They may also ask for a tour of your facility. The employer may elect to have a representative present at any time during the process except for the private, non-exempt employee interviews. However, be sure that this person has the authority to make decisions and commit to corrective actions such as policy changes and the knowledge to answer all questions about company policies and procedures. This representative can monitor the investigator and somewhat influence the scope of the investigation, thereby protecting the employer's interest. But perhaps the most important role that the representative can play is to emphasize the employer's commitment to compliance. The investigator is allowed to hold private interviews with non-exempt employees, but the employer representative is allowed to be present at interviews with exempt employees. This is where job descriptions become so very important. You must be sure that your employees are doing what they are being paid to do and not doing what they are not being paid to do. You can be certain that the investigator is going to ask Johnny what he does when he is working. And if he is misclassified exempt or non-exempt, or if his job description does not fit his actual job, that's almost a guaranteed violation. These interviews may be telephone interviews, questionnaires, or face-to-face during non-work time. After the investigator has reviewed the requested documents and completed any interviews, a final conference will be scheduled with the employer. Again, make sure that the employer's representative who is present at this conference is someone who can make decisions and commit to actions required. If any violations were determined, they will be explained at this conference, and also any actions required to correct the violations. Calculations of back wages and repayments will be requested at this conference to be reviewed and approved by Wage and Hour. The employer is permitted to give additional evidence to be considered if any violations have been discovered. Where violations are found, employees may sue for back wages, attorney fees, and court costs. And if the employees do not sue, the Secretary of Labor may file suit for the employees. Court injunctions may be issued to keep employers from perpetual violations. Civil fines may be assessed for child labor violations and repeat or willful violations of FLSA. Willful violations carry criminal penalties, including fines and prison. One of the chief concerns of the Department of Labor, as I mentioned earlier, is retaliation. Employers are strictly forbidden to retaliate against employees for filing complaints. Employees are entitled to reinstatement of their jobs if they've been lost, and also to lost wages. Where violations are determined for employers who hold government contracts, the employer risks loss of those contracts and loss of eligibility for future contracts for a specified period of time, as well as repayment of back wages and liquid damages like court costs and attorney fees. So before you ever get selected for a DOL audit, put some best practices in place. Make sure you record all time worked on time cards and keep those time cards for the required amount of time. Tell your employees not to work off the clock and discipline them for doing so because you've published that in your policies. Have employees sign off on time cards, although the Fair Labor Standards Act does not require this. Record all off-site work. Record all meal and break punches. Make sure the timesheets actually match your pay stubs. Perform your own internal audits before Department of Labor comes in and does their audit. Audit your job descriptions. Look at your jobs. Look at your job postings and your org charts. Does it all fit together and make sense? Identify potential problems and make an effort to fix them. Auditors like good faith efforts. And if you're concerned that you have a problem, there are employment practices liability insurance policies that you might want to consider if you want to go to that expense. If you do get an audit notice, act immediately to prepare. Be calm and courteous and respectful of your auditor. Don't start out on a bad foot by being defensive. Build your team to gather your data and assist with the audit. For every phone call you have with the DOL representative, follow up with a communication in writing. Create a plan that you communicate to everyone involved at your organization. Find or create a workspace for the Department of Labor investigator. Find or create a place for the private interviews with the non-exempt employees. Explain to your team members what they should expect. Review all documents before you submit them to the investigator. Don't just hand over a pile of papers that you haven't laid your eyes on yet. You should be proactive, and when you see flaws in your process, attempt to improve them. Know what red flags the investigator will be looking for so that you can have them cleaned up before they become an issue. Red flags that auditors will look for first include misclassification of exempt and non-exempt employees, overtime issues like averaging hours over multiple weeks in order to avoid paying overtime, incorrect calculation of regular rate of pay, using comp time instead of paying overtime, not including bonus amounts and regular rate of pay, and how you pay tipped employees. They'll also look for off-the-clock work. They'll check for improper deductions. They'll look at your break and meal punches. They'll check your record keeping. Make sure you're keeping the correct records for the correct length of time. And they'll look at your overtime calculations. More than a third of complaints for wage and hour are concerned with overtime violations. Here is the website for the Department of Labor, also their phone number and their hours where you can contact them. And also here's a link to a fact sheet number 44 regarding visits to employers. It's got a lot of the information we've covered today, but some additional information as well. I'd like to thank you for joining us today, and we hope you've learned more about Department of Labor investigations and what to expect if you ever need to prepare for an audit. Please be on the lookout for more of our educational webinars soon, and email me if you have any suggestions for topics you'd like to see in future webinars. Thanks, and have an optimum day.